This week on the Communicators, the start of a 4-week series looking at privacy and telecommunications policy. Our guest today is David Vladeck with the Federal Trade Commission.
David Vladeck, as Director of the Consumer Protection Bureau for the Federal Trade Commission, what are your jurisdictional areas when it comes to online privacy?
We regulate virtually every industry that engages in online tracking, online sales, except for insurance companies and banks. So the key actors in this industry, the ad brokers, the analytics companies, and the sellers, and the publishers like the Wall Street Journal or the New York Times, are all companies that fall within our jurisdiction.
What about the manufacturers of the operating systems like Microsoft, or the manufacturers of the chips like Intel, who can build in privacy factors into their equipment?
Right. They too are subject to our jurisdiction. We just settled a major antitrust case against Intel yesterday.
When it comes to online privacy, how does it rank in the Obama administration?
We're an independent agency, so I can only speak to the Federal Trade Commission's interest, but it is a very high priority. We began last year an initiative to take a hard look at all dimensions of the privacy issues that we regulate, and we've been working very hard on that ever since then. So this is very important for us.
Julianna Grunwald is with the National Journal. She's their Tech Daily Dose editor. She's joining in the questioning.
You had held a series of roundtables on privacy in the last year, and I'm told that you're going to be putting out some guidelines in the fall. Can you talk about what they would do, who they're aimed at, more specifically when they might come out?
Well, we're hoping to come out in the fall, as you pointed out. These will not be guidelines in the sense that this won't represent our sort of final thinking on these issues. This will be a draft document, and part of what we've done with roundtables and other meetings is to try to get all the stakeholders together to figure out where there are points of consensus and where there are points of disagreement. But what we're hoping to do is formulate guidelines that will increase transparency. One of the concerns is that most people don't know they're being tracked. Two is come up with clear and meaningful ways for consumers to exercise some control and some choice. And third is to identify those areas that are most critically important: sensitive information and uses of the information beyond the sort of the online behavioral advertising that we've seen already. And so those are some of the key issues that we're going to address in the guidance that we put out in a tentative form in the fall and hope to finalize this year.
In your testimony before the Energy and Commerce Committee on July 22nd, you said this: if legislation is enacted, the Commission believes that it is important that it incorporate the need for simplified disclosures at a relevant point for consumers. FTC rulemaking authority could provide guidance for this requirement. How does that tie into Julianna's question?
The question in two ways. First is we don't currently have regular rulemaking authority in this area. So it's not as though we can put out a binding rule that companies would have to observe. At this point in time, all we can do is give guidance. That's the limits of our authority under the statute. But the second part of the question is this: we very much would like to move to a regime in which people get short, clear privacy notices when they are useful to the consumer. So consumers understand who's tracking, what's being collected, and what it's going to be used for. And if we can formulate some kind of universal, almost like a label that you'd see on a soup can for privacy, maybe we can encourage companies to compete on privacy grounds. And so what we're trying to do is figure out how you give the information that's most important to consumers in a clear and concise way at the most relevant period in time.
You mentioned tracking. Do you think consumers are aware of how much tracking is going on online? The fact that if they go online and they look up SUVs and they go to a different website, they might suddenly see an ad for an SUV. Do you think they're aware of what's being tracked? Their activities are being tracked when they go online?
Very few consumers, I think, are aware of that. And there is academic research. I mean, just a few months ago, the Annenberg School at the University of Pennsylvania and researchers at Berkeley came out with a report that I think, reinforced everybody's intuition about this, which is that most consumers do not understand, A, that they're being tracked at all, or B, just how robust the tracking is and how much information, not necessarily about them, but about their browsing habits, are being tracked and analyzed by analytics companies and others who sell that information.
You mentioned, do you think there should be some controls on that? Chairman Leibowitz at a recent Senate Commerce hearing mentioned the idea of a do not track list, similar to the do not call list, which is aimed at telemarketers. And can you elaborate on that?
Well, this is an idea that we and many other people are taking a look at, which is and it's another way, and it's a very clever way of sort of giving consumers the opportunity and the means to prevent being tracked when they're online. Now, there's some technical issues with do not track. It's very hard these days to come up with a browser or some other search device that would in fact ensure that you weren't being tracked.
Why is that difficult?
Because there's some technologies that are hard to defeat. So there are tracking devices like flash cookies and certain web beacons. I mean, technologically complicated devices that are not easily overcome by some of the browsing technology. So I'm not suggesting that we're not looking very hard at this, but I'm not sure that today there is technology that would be perfect in terms of ensuring that when you went online you were not tracked.
If you could work out these technical issues, would this be part of this guidance that you plan to issue? Is this anything you could mandate? I mean, you said you have limited ability to mandate certain things, but
right, we could not mandate a do not track. Congress, of course, if it chose, could mandate something of this form. We would encourage the development of some sort of universal system so that consumers could, on one screen, not having to go to a bunch of different advertising networks and others, disable the tracking features. So they could engage in a search essentially, not simply anonymously, but so there would be no trace back to the computer or device they were using to browse the internet.
But David Vladeck, wouldn't that be something also that the manufacturers of the operating systems could build into their technology, into their systems? Or is it to their benefit to be able to have tracking?
Well, that's a great question. I think the browsers, the people who make the technology, are close to having the technology to come up with systems that would allow for you to browse without being tracked. I think that many of these companies also make a lot of money by selling the data that's acquired through tracking. And so, as you know, Microsoft almost came out with a browser that would have as its default a do not track feature. But ultimately, the company chose not to use that as the default because it was worried that it may impair advertising revenue for it and for companies like it.
And I want to go back to your July 22nd testimony before the Energy and Commerce Committee. Consumers often do not understand relationships between companies based on corporate control. Thus, if a company states that it does not share data with third parties, consumers may be surprised if that company shared data with dozens or even hundreds of affiliates.
Right. This is the affiliate question. So if you look at privacy policies, and nobody does except for, I think, my colleagues at the Federal Trade Commission, but if you really read them, oftentimes they say something to the effect that we don't share with non-affiliated parties. Now, oftentimes, I think if you were to read this, you might say, well, affiliated parties would be parties that have the same brand name, you know, Coke, Coke Light, whatever. But they don't necessarily mean companies that are engaged in a completely different business model or don't share the same brand. So,
can you give us an example? Would it be like the web services that Google offers many firms? I mean, is this what we're talking about?
Well, that could be, but what I was talking about was something more basic. So, you know, and I'm just going to pick on one company, but Proctor Gamble's, people know that it makes soaps, but it also makes Pringles and all sorts of food products and so forth. So if you're if you're on a site looking at one of their products and it's a home cleaning product, it may be fine for you if they share that with other products of the same kind. But might be a real surprise to you if they were in other businesses that did not bear the Procter Gamble name. And that's a concern here. We have this problem in a related area with financial products. The Gramm-Leach-Bliley law forbids, without certain notice, the sharing of financial information except to affiliates. And as you know, some of the big financial giants have affiliates in every financial service and product. And so that was what that remark was really aimed at.
There is, in the Wall Street Journal, a recent series on online privacy and tracking.
Right.
And one of the articles was on the web's cutting edge, anonymity in name only. And it talked about the company X+1
Right.
and how it can predict if you're going to be a good customer, what kind of customer you are, with just a few keystrokes, and by tracking the websites that you go to. Is this common?
When you say this, the tracking is common, the ability to aggregate this data is common, and the use of this data for delivering highly targeted ads is ubiquitous. So I think that's a long-winded answer to your question, but it's yes. And I wanted to make sure that each of those components was clear.
And what's your view on that, David Vladeck?
I think there are two sets of issues that we have to worry about. One is, I don't think that the delivery of targeted ads is what has people worried. I think some people are concerned about, how did I get this ad? But I think the concern, the most intense concern comes up in two ways. One is when people are looking at sensitive issues, health issues, family issues, financial issues. Suppose, and this is a purely hypothetical question, I was worried about hair loss, and I was searching, a website to find out the cause of it, and I all of a sudden started getting targeted ads for that. That might disturb me, but if I had a more serious illness or I was worried about my health in a more profound way, and I started getting targeted ads about that, I think I'd find that very off-putting. And under our current regime, that happens. The analytics companies, like the ones that were described in the journal article, can deliver precisely those ads. So there are areas of sensitivity that we need to address. There's also the lurking question. I think this is really what gets people most concerned. These aggregations of data are being now used for targeted ads, but they are very detailed, they're very rich, and there is the possibility that they can be de-anonymized. So you could actually link this information not just with an IP address, but with a human being. And I think people are worried about this threat that there's this enormous amount of data out there about them that can be used for purposes other than targeted advertising.
There's the issue of data breaches. I mean, they have these dossiers about people, and there have been some well-known data breaches in the last year or two. What would you like to see done on that? I know there's a couple bills in Congress that have been introduced. One was introduced this week by Senator Pryor and Senator Rockefeller of the Commerce Committee. But what do you think can be done? Is there anything that the FTC can do absent congressional action?
Well, we are very engaged in this space. We have brought 29 actions against companies over data breaches. Last week, we settled a case against Rite Aid that was dumping patient information in a dumpster. A month ago, we settled a case against Twitter that had insufficient protection, and so people were able to hijack the site, but in addition to that, to get access to personal data. Now, we don't have civil fining authority for data breaches, and my concern is we don't generally have very broad civil fining authority. My concern about data breaches is that we haven't had sufficient deterrent effect where companies are storing, as you rightly put it, very sensitive information. And so, I mean, in Rite Aid, it was information about people's prescription drugs. And so I would like to see this regime be toughened up. Both houses of Congress are deliberating on data security legislation. The Commission has taken a position supporting that legislation. But we need to have more robust authority in this area to deter these kinds of data breaches.
Now, you mentioned data security, but there's also just a broader privacy bill that Congressman Boucher in the House is working on, and Congressman Rush. Can you talk about that a little bit? They seem to favor a general opt-out, except for some third parties, but that wouldn't include ad networks, I believe. Can you talk about that a little bit and where the FTC stands on that?
Well, we haven't taken a formal position on either bill. Chairman Rush's bill was just formally introduced about 2 weeks ago or 3 weeks ago. Let me make some general observations about the bills. One of our concerns with the House approach is that it permits safe harbors. So if a company that is involved in the collection or use of data is part of some industry consortium, you would be allowed essentially a very weak opt-in. You just have to give notice of that. We're worried that at this point there's not enough uniformity in the way these programs work to guarantee a consumer any assurance that if he or she signs on to one of these networks, that they won't be tracked in ways that are not consistent with consumer expectation. So we're worried about that. Both bills also put enormous emphasis on privacy policies and require very detailed privacy policies. Now, we're not opposed to notice, but what we're worried about is that neither bill concentrates on what we think is imperative, which are short, concise, just-in-time notices to consumers about what's being collected, who's doing the collecting, and what the data is going to be used for. And I think earlier you quoted part of my testimony about the need for clear and concise notice, and neither bill adopts that approach.
This is C-SPAN's Communicators program. Our guest is David Vladeck, who is the director of the Consumer Protection Bureau for the Federal Trade Commission. Joining in the questioning is guest reporter Julianna Grunwald of the National Journal. She is the Tech Daily Dose editor. Julianna Grunwald, what is Tech Daily Dose?
It's an online blog that covers telecom and technology issues all over the map.
And where can people find it if they're interested in reading it?
You can go to nationaljournal.com and click under our blogs tab on the left, and you'll find Tech Daily Dose right there.
Next question for David Vladeck.
Can you talk a little bit about your work on children's online privacy? There's a rule that you're taking another look at related to the Children's Online Privacy Protection Act.
Sure. This is a statute that generally forbids the knowing collection of information online by children 12 and under, unless there's explicit affirmative consent by parents. We're worried that the online environment is developing so rapidly that the original statute and our rules enforcing it are out of date already. For example, it doesn't necessarily apply to certain applications on mobile phones. It doesn't necessarily apply to online gaming sites of the kinds that we see. And so we held a roundtable a few months ago. We brought in all the stakeholders and all the experts to talk about whether it was important to revise our rules on this very, very important statute. We haven't reached a final decision, but I think there's real concern. There was also concern about advertising to children online and whether we needed to step in to see if there were protections that we could build in to insulate kids from this as well. I need to caution that these are complicated issues and we're just taking a look at it, but I suspect in the next year or two we may have to revise our rules.
David Vladeck, a lot of people are pretty uncomfortable with the amount of information about themselves that's already out there somewhere in cyberspace. Is the horse already out of the barn in this case? I mean, the information is out there somewhere and it's kind of floating around. Is it too late to stop or to enforce privacy on the internet?
Again, let me unpack that question because I think there's a premise to it that may not be correct. So there's a lot of information about who is using your computer and the browsing history on that computer. That's being looked at by companies that want to advertise to you through that computer, but they don't necessarily know who you are. And finding out exactly who you are would be very costly. They know your demographics. They know generally your age. They know generally how much you make. They may know something about your interests, but they don't exactly know who you are. Now, if they wanted to, and they were willing to spend some money, and they had acquired sufficient amount of data, they could figure that out. So that's one issue. The other issue are the social networking sites, where you have presumably or possibly, there are 500 million users of Facebook now, maybe you were one of them. You may have posted information that you think is available only to a very small handful of people that you permit to get on your site. And that may or may not be true. And so I think in answering your question, it's important to ask which bucket of concerns are you addressing? Is it the behavioral advertising bucket, or is it the self-posted information that you may or may not have put on like a Facebook?
Julianna Grunwald.
Are you giving up your rights to a certain extent when you go on Facebook and you put information? Granted, you have privacy settings, but do you think in some ways people are giving up a little privacy by agreeing to go on a Facebook and putting their information out there?
I don't know whether I'd put it that way, and I hope they're not. Our rule is that if a company like Facebook is entering into a bargain with you, you're going to post your data on their site, conditioned by a privacy policy that gives you some controls. The company has to abide by that. And if they make material changes, or if they want to make material changes in that privacy policy, they have to ask you, and they have to get your permission before those changes are made. So, I hope that you're not giving up more privacy than you agree to give up. To us, that's the fundamental bargain here. But I think the answer to your question is that we now know personal data is a commodity, and it's being traded in online auctions every minute of every day. And part of our goal is to make sure people understand what the nature of that bargain is and how to make sure that they're comfortable with that bargain.
David Vladeck, given the global nature of the internet, how does that affect what you do at the FTC?
Well, most of the companies that are driving this process are U.S. companies. And so when I go abroad, people are very anxious to know what are we doing. But I don't know in terms of the privacy issues, the fact that we have a global economy changes very much. It certainly does in the fraud context. That is, we see lots of frauds being directed at U.S. citizens from outside our borders, and we are entering into both international and bilateral agreements to help us bolster our law enforcement capacities. And I think we're reasonably successful. But in the in the privacy realm, these are global companies, but we have jurisdiction over them. So it's not as though there's a company in a different country that's doing this. We are worried, of course, and this is a more universal concern, about the effects of cloud computing. It's not at all...
Which is something that the Obama administration has been pushing.
Right. Cloud computing, without a question, offers all sorts of economic benefits. It does raise questions, though. Suppose you are on a social networking site that has its servers in a different country, and there's a data breach. We take the position that they are subject to U.S. law, and we would sanction that company as if the servers were just down the road. But it does raise questions.
Would you sanction the company whose data is being stored, or would you sanction the company who's running those servers in the other country? I mean, you probably wouldn't have jurisdiction over that, the company in the other country that's actually operating the servers.
We would require any company to take reasonable precautions to make sure the data was safeguarded. And so if a social networking site chose to store its data outside the territorial limits of the United States, we would hold the social networking responsible because, in our view, it would have a duty to ensure that anyone that it dealt with maintained adequate and reasonable safeguards. So we would go after the social networking site, even though the data breach may have occurred somewhere else.
Do you have adequate authority? This sort of goes back to my earlier question about the legislation, and one of those bills would require that if there's any data breach, consumers are notified within 60 days that there's been a data breach and they could possibly be subject to identity theft. So do you need legislation to mandate that kind of action?
We do not need legislation to mandate that kind of action. I mentioned earlier that we've brought a lot of data security cases, right. And where necessary, we've required companies to do all of the things you're talking about and much more. What I was mentioning earlier is that we do not have the authority at the moment, except in some discrete areas, to impose civil penalties for data breaches. And some of the data breaches, such as throwing prescription data in a dumpster, in our view, are just intolerable. And, had we had civil penalty authority, I think we would have tried to exercise it in a case like that.
David Vladeck, we have time for one more question from each of us. When it comes to financial security and privacy, are there special rules when it comes to, because so many people do online banking now, et cetera?
Yes, there are special rules. And we're quite vigilant, as are the banking agencies. I am worried about we haven't mentioned one really key issue, which is the transference of computing to mobile devices. And Citibank just announced last week, and we had already figured this out in our forensic labs, that if you did online banking, at least I think they fixed this, but with Citibank, your hard drive on your smartphone would retain all of your financial information. Now that, to us, is a serious problem. So there is going to be a huge migration to smartphones in terms of payment processing, and so forth. And that's an area we're taking a very hard look at, because we need to make absolutely certain there are adequate security controls on these new devices, and that the applications that permit you to do this are not easily hacked into.
Final question.
Do you think there's a way to find a balance between the need for online companies to make money from advertising to support free contact and ensuring adequate privacy? I mean, where do you find that right balance?
I think that's an important question. The New York Times company reported its quarterly earnings a few weeks ago. 26% of its advertising revenue came from online ads. We need to make sure there's an advertising stream. I think that if all you're talking about is targeted advertisements, I'm not sure people would be as worried about privacy implications as they are now, where there is concern that sensitive data is being acquired and may be used. And people are worried that this data that's being collected for advertising purposes might be used for some other purpose beyond their expectation.
David Vladeck is the director of the Consumer Protection Bureau for the Federal Trade Commission. Julianna Grunwald with National Journal. Her website is Tech Daily Dose. Thank you both for being on the Communicators.
Well, thank you.